Hey everybody, I want to thank everybody for watching the video explaining the Tory Lanez guilty verdict. I appreciate you taking time out of your day to watch it. All the people who said kind things or share it, I appreciate that. I also appreciate the people who argued and continue to argue and disagree with me because that helps me learn what is important for me to get across to people and how to express myself better to get my point across. So it turns out my video got shared on TikTok, which I have an account, but I never use. And in response to all the views on TikTok, I've got a number of very specific questions. So I want to answer those, and I want to answer a fifth question, which I think underlies all the other questions, which wasn't specifically asked. But I'm going to try to do this as quick as possible. I understand I'm a lawyer, so generally I get paid by the word. And that's part of the reason we are loquacious, which means we talk a lot. Number one, the question that I was asked, why do you think the issue went to trial? Because Meg didn't press the issue. I think this case went to trial mainly because the prosecution on paper thought they had a slam dunk case. Number one, they had a witness who was willing to testify. Not immediately, but when Meg became willing to testify, she became very adamant and clear about getting shot. She gave the prosecutor a clear motive based on her statement saying that Tory said dance, B word. You can disbelieve it. And a jury can believe it if they so choose. But physically, they had clear corroboration from the physical evidence, which is the bullets in the foot. And they expected Kelsey to testify consistently in court with the statement she made in September. Prosecutors always expect a witness to testify consistent to whatever statement was collected in their office. It was very clear the prosecutors seemed to be unaware of the personal rift between Meg and Kelsey that happened subsequent to this issue, or they just didn't care. And they obviously expected Kelsey to come to court and testify consistent with that September statement. We know that because we heard the opening statement where they told you precisely that, what she was going to testify to, and the way they got what she was going to testify to. They took that information from the statement she made when she was in their office, which I believe her husband was present at the time. So what does all that mean? They had a direct accusation, they had a corroborating statement, and they had corroborating physical evidence. That's what they saw. To a prosecutor, that's an easy case. That's not a hard question to prosecute at all. Now, had Meg stuck to there's glass in my foot, or had she told them that she's going to stay in Texas and not come back to California to testify, I think they may have not proceeded on the case. They may not have been able to, quite frankly, but neither of those things happened. So that's all an imaginary what if alternate history story. Number two of what I was asked, will the public ever see the video the jury saw? Now, that's a very specific jurisdictional question, so I can't answer because I can tell you what would happen in my jurisdiction. The news or a reporter could go down and just file a simple document request at court in order to see that information, that evidence, unless there was some sort of restriction on it issued by the judge. I honestly can't tell you how they do it in Los Angeles. I assume it's somewhat similar, but it's up to them. Number three, is it true the bullet fragments are lost? My understanding is yes. The bullet fragments were lost by the Los Angeles the police department somewhere on the evidence room or on their way to the evidence room or in the evidence room. Now, I think I addressed this in the longer version of this video on my YouTube page, Hawaii Lawyer. You can watch that or not. It's up to you. But a better question than were the bullets lost is, what do the bullets lost actually affect? The prosecutor stated there were bullets. The defense stated there were bullet fragments. And you had a trained surgeon say he removed them from the foot, that they were bullet fragments and he removed them. Why is this important? Because no one is asking to re-look at the bullet fragments. It's not like a drug case where the police are lying about the contents of drugs in a package, and an independent testing facility could test to see if it really was drugs or if it was fake drugs, bunk, for example. There's no debate about whether these are bullet fragments. Ask yourself, how would the trial be different if these bullet fragments existed and they could be brought to court? If the answer is not at all, that tells you it's not necessary for them to be put into evidence. Now, again, you could say she said glass, but the doctor found bullets, and therefore Meg is a big liar, and therefore there's reasonable doubt in the case. That's fine if you want to believe that, but that doesn't mean everybody else who sees the same evidence has to agree with you. I'm going to address that in the question number 5. So, yes, the police absolutely handled that part of the investigation poorly, as well as other parts of this investigation. But if their handling doesn't affect anything, we just keep it moving. What do you want to test those bullet fragments for? Again, if the answer is you don't need to test them for anything, then you have your answer right there on if they need to come into evidence or if it affects the trial in any way. Number 4, does the free Tory petition give any gravity for him to get an appeal? 100% the answer is no. There will be an appeal. It's undoubtable. Tory will attempt an appeal. If I forget, I think I addressed this in the other video, the specific appeals issues, but Kelsey's September statement obviously is a big appeals issue. Number 2, there's an ineffective assistance of counsel appeal issue. If they were so unprepared for trial that it was a constitutionally bad defense. I don't want to make a comment on that now. I don't know what the evidence is going in. I have no idea. But I know a lot of people are accusing that. If it is, that could also be an appeal issue. My bet is they did the best job they could with a bad case. But let's dial it back a second. What is an appeal? An appeal is when a higher court looks at a lower court's actions, a judge's actions, and decides if the judge followed the law the way they were supposed to follow the law. What isn't an appeal? An appeal is not a new trial. An appeal is not a way to put evidence before either a jury or a panel of judges. An appeal is attorneys looking at prior cases, that's called precedent, that have been decided by appeals courts, and seeing if the judge in this trial broke some law, let the evidence in, or kept out some evidence that needed to be let in. And because of that evidentiary ruling, that changed the course of the trial. And it shouldn't have. It wasn't that the evidentiary ruling they made, they weren't allowed to, and that affected the course of the trial. Basically, because of that illegal evidence, either kept out or brought in, the trial itself was not fair. Appeals are decided on the trial record that was created in court. The same thing that was reported to us from the blog sites and the Twitterverse. Many pages of documents written by attorneys, cross-referenced with prior court decisions, that's the precedent, are put in any number of binders. The briefs reference to the record of the court hearing. So, the better question is, will Tory win the appeal? My gut tells me he won't, because Meghan's testimony alone is enough to convict Tory. I know that gets a lot of people angry to hear, but it's true. Now, I can't tell you the validity of the lawyer's arguments on appeal when those arguments haven't been made yet. But my reserved answer is I doubt he wins. That being said, Bill Cosby is a free man because of an appeal right now, and Jussie Smollett is out of custody pending appeal right now. Finally, I want to answer one more question which wasn't asked, but which is the same thing that runs through many of the responses I get on the comments in the last video and what I'm seeing around. For people who are saying there's a mountain of reasonable doubt in the case. The jury's job is to determine what to believe. They can believe any witness in whole or in part, or they can throw out any witness's testimony. So if you find yourself seizing on one piece of Kelly's testimony and then saying how it contradicts one piece of Kelsey's testimony, and therefore Meg is a liar because she said one thing on TV, and therefore we can't believe anything she says, it's okay for you to believe that, and it's okay for you to say that if you were on the jury, that's the way you would decide. But what's important to remember is that you're not on the jury. My gut feeling here is that Meg testified very credibly, that she testified as she explained away her prior falsehoods, and that the jury believes she told the truth as to the important parts of the accusation, that the shorter man pointed a gun in her direction and fired. The important parts of Meg's testimony resonated with what Kelly and Kelsey said, and the parts that didn't comport with that, the jury, I believe, either assigned that to willful misrepresentation or innocent misunderstandings or misperception. So while it's fair to say you had a reasonable doubt, juries may believe different than you. And we have to remember they're watching the witnesses and looking at the evidence live in the room, seeing which direction people's eyes go. Are they looking down? Are they responding with a loud voice? Are they strong or are they soft? And is that something they want to believe or not believe? When we're reading a flat transcript or listening to a person who's interpreting what a witness may have said in the courtroom because we're not there, the famous example is a transcript may say, quote, "I killed my friend," but in real life, the person was accused of something and their answer was, "I killed my friend?" Like a question. It's very important, even in the courtroom with lawyers, it's important that we remember that the same statement can mean different things to different people in different contexts. That doesn't mean there's reasonable doubt. What that means is a jury has to decide if they can determine what it meant in that context. In this context, the jury clearly did. Anyway, thank you all for watching. If you have more questions, I'm happy to answer them. Subscribe or share if it's worth to you. And let me know if there's any other cases I can interpret. I'd love to try and interpret any case which isn't an employment law case. Thank you very much.